Today, the judge in former President Donald Trump's federal election subversion case making it known she's not considering the 2024 presidential election or Trump's campaign schedule in deciding next steps in the case. In the first hearing since the Supreme Court's immunity ruling, Judge Tanya Chutkan pushed back against Trump's legal team, saying the November election is not relevant as she decides how the case will move forward. CNN senior crime and justice reporter Katelyn Polantz is live outside the federal courthouse for us here in Washington. Katelyn, what more did we learn from today's hearing?
Well, Boris, it was quite a zippy hearing for about an hour and 15 minutes. Judge Tanya Chutkan went back and forth primarily with Donald Trump's defense lawyer, John Lauro, who's trying to put things on hold as long as he can to make things last a long time so that they can do legal arguments, gather their information, look at things. But inside this building, in Judge Chutkan's courtroom, the election just is not playing a role for Donald Trump as a criminal defendant. A quote from the judge: "I'm not talking about the presidency of the United States. I'm talking about the four corners of the indictment." Yet they still have to talk about the presidency because in this case they have to figure out what to do with presidential immunity and how it applies here to Donald Trump after the election, especially in his exchanges with the then Vice President Mike Pence. And the Justice Department is prepared in just a couple weeks to start laying out evidence, if the judge wants it then, to put in papers, grand jury transcripts, interview records, documents, FBI memos, all kinds of pieces of evidence we've never seen before that aren't even mentioned in the indictment. They're ready to go if that's what the judge wants to do next.
So, Katelyn, what are we anticipating is going to be the next shoe to drop? What comes next?
Well, today even, we could have Judge Tanya Chutkan's decision on what the schedule is going forward and when the Justice Department could potentially be laying out this evidence that they say they have ready to share and make public to a certain extent. The thing, though, that we don't have at this time is a trial date. The judge is pretty clear she's not going to set one at this time because everybody in this case agrees, Boris, there's going to be at least one more round of appeals that's going to put everything on hold.
Katelyn Polantz live outside the federal courthouse. Thank you so much. Let's discuss further with John Dean. He served as White House counsel for former President Richard Nixon. Also with us, former federal prosecutor Jennifer Rogers. Thank you both for being with us. First to you, Jennifer, was today a win for one side or the other? How do you read it?
Well, not really a win for one side or the other, I would say. I mean, Judge Chutkan, who I continue to be impressed by the way, continues to kind of give each side some of what they want, but not all of what they want. I think if you had to pick, you would say it was a win for the government because Judge Chutkan made clear that she doesn't agree with Judge Cannon in Florida's dismissal of that case on the grounds that the special counsel was not properly appointed. And she also doesn't seem inclined to string out this series of motions and let them do one at a time and all that sort of back and forth that would take months and months. On the other hand, the government wanted her to reject as waived the arguments, some of the arguments that the Trump team was making because they didn't make them soon enough pursuant to the prior schedule, and she seemed inclined to consider those. So she gave each side a little bit, but continues to keep tight reins on this thing to move it along to the extent that she can.
John, what stood out to you in court?
In particular, I would say the fact that she doesn't think this election that is all around us is going to influence her decision on this case at all. And that's actually the norm and the way it should be, unlike some of the other cases where it's playing a bigger role. So I think that's the most standout point to me, that she's all business, no politics in her courtroom, and we're going to get a schedule today, and that will resolve a lot of these issues.
I love the way John described the election. It's all around us. It's all consuming, it seems at times. John, I'm curious about how you think Judge Chutkan is going to approach this superseding indictment. Is she inclined, does it seem to you, to leave it as is or potentially ask for more changes?
It appears to me, based on the hearsay reporting we get out of the court secondhand, there may be a transcript later today too, or soon thereafter, and we'll have a better idea. But it seems that she's going to try to make some sense out of the Supreme Court's ruling, that she's going to dive right into the issue of whether or not Mike Pence, the vice president, can be a player in this trial or not. The government wants that. They want to cast him not as his role as vice president, but as the president of the Senate and a candidate for re-election. So that, and I heard nothing that she rejected any of that outright, notwithstanding arguments by Trump's lawyers. So I thought I had a very good feel about today, that we're in the hands of a very competent judge, and she's going to make some very clear decisions today that will, as a result of scheduling, and we'll have a better feel at when that schedule comes out.
Jennifer, how could this issue of Mike Pence and whether what he was doing was, an official act or an unofficial act, how could that affect the strength of the special counsel's case?
Well, I think one of the reasons they wanted that part of the criminal scheme, the pressure campaign on Mike Pence, is because it is one of the strongest parts of the case. I mean, these phone calls and all of this pressure as the other parts of the scheme were failing and were not getting Trump what he wanted. The last ditch effort to get Mike Pence not to accept the real electors and to throw it all back into for voting was a huge part of this, a really damning part. And so I think they really want to keep that in. Judge Chutkan's challenge, though, is to just make sure that it is properly staying in. I mean, no one, not the judge certainly, and not the prosecutors, although I shouldn't say no one because I think Team Trump wants this. They don't want to go up the chain again twice, right? We know we're going to have appeals on the immunity decision that Judge Chutkan makes. We don't want to have it go back up and then come back down for further findings. Be very careful to evaluate all of this with a very close eye on this Mike Pence evidence and hopefully get it right so that we only have one more set of appeals before she can set a trial date.
And John, I'm curious to get your reaction to Judge Chutkan saying that anything that she decides is going to get appealed. She sort of notes that the entire process is going to be challenged the entire way through by Trump's legal team in myriad ways. What did you make of that?
Well, the fact that she's open to the idea that she'll entertain whether they can even appeal whether the special prosecutor is properly appointed, while she wouldn't let it in today and they're not timely, she didn't throw it out as something they couldn't even raise, shows how fair she is and how she's going to look at everything. So in that context, the fact that she'll be reviewed on everything is not terribly surprising. But she's a good judge, and I think she'll make the right decisions in these cases. She will be fair, and so she'll probably survive.
Start with a big day in our law and justice lead today, with a heated hearing in Donald Trump's federal elections case in Washington, D.C., relating to his actions on January 6, 2021. This is the first since the U.S. Supreme Court handed down their landmark presidential immunity ruling in July. This is the case where Trump faces charges for his alleged efforts to overturn the 2020 election results, which culminated, of course, in the Capitol riot. You will recall, perhaps, last week, Special Counsel Jack Smith narrowed the charges he was bringing against Donald Trump so that the case would still qualify, even with the U.S. Supreme Court's immunity ruling. Today, in the hearing, Trump's lawyers offered two key arguments. One, that the appointment of Special Counsel Jack Smith was illegitimate. And two, that the whole case should be thrown out if the judge ultimately finds that Trump's interactions with Vice President Mike Pence were deemed immune from prosecution. Judge Chutkan today offered a chilly reception to both of those defense arguments, and she pushed back against the Trump team's assertion that they were worried about this case playing out publicly in the final days of the election. Judge Chutkan asserting, quote, "This court is not concerned with the electoral schedule," unquote, to which Donald Trump's attorney John Lauro responded, quote, we're talking about the presidency of the United States, unquote. Chutkan responded, "I am not talking about the presidency. I am talking about a 4-count indictment." This all comes as Donald Trump this afternoon fought back against his legal cases, accusing Democrats and Vice President Kamala Harris of trying to imprison him.
She and her party are censoring speech, weaponizing the justice system, and trying to throw their political opponents, me, in jail. This hasn't happened. I didn't do that to Crooked Hillary. And they always have to remember that two can play the game.
We're going to start today with CNN's Paula Reed, who followed the ins and outs of today's dramatic hearing at the courthouse.
It's a total fraud. It was election interference.
Donald Trump's January 6th case back in D.C. federal court today with a fiery and contentious hearing. Attorneys for the former president seeking an immediate dismissal to the case. We have an illegitimate prosecutor, we have an illegitimate indictment, and we have illegitimate legal issues raised in that indictment, Trump attorney John Lauro said. The judge, Tanya Chutkan, made it clear that was not going to happen. The Trump team sparred with her over a timeline for the case, calling it unfair to introduce evidence this close to the 2024 election. Chutkan responding, I understand there is an election impending. You have said before, and I will say again, that the electoral process and what needs to happen before the election does not matter here, and that she was definitely not getting dragged into the election. But there was one area of agreement. The judge must decide how a Supreme Court ruling on presidential immunity affects this case before any trial. Immunity is the linchpin here, she said. A 6-3 decision in July gave former presidents immunity from prosecution for official acts, but not for private conduct. Attorney General Merrick Garland said this week he was confident in special counsel Jack Smith.
I stand by the actions of the special counsel. The superseding indictment is an effort to respond to the direct instructions of the Supreme Court as to how to effectuate a new indictment in an ongoing case.
While the new reworked indictment removed things like Trump's infamous Rose Garden video.
So go home. We love you. You're very special.
It added new details about Congress's certification process and what role Vice President Mike Pence played in it. Trump's attorneys arguing on Thursday that the case should be tossed if the judge rules communications between Pence and Trump are immune from prosecution. It tanks the entire indictment, Laura argued. They also intend to raise other issues, like the legitimacy of the special counsel, questions about obstruction of justice on January 6th, and discovery. But one question that won't be answered anytime soon is when this case will go to trial. It is sort of an exercise in futility at this point to talk about setting a trial date.
And in talking to sources in and around this case, it is clear that if this case does go to trial, it would not do so until next fall at the earliest. Now, Jake, the judge could release her plan, her schedule, as soon as this evening.
Ellie, turning back to the Trump case earlier today, you said today was a good day in court for special counsel Jack Smith, but he still has one of the most complicated cases in the current justice system.
Yeah, for sure. I think today went well for Jack Smith, but he's still up against it when it comes to this case writ large. Now, a couple things I think look like they went well for Jack Smith today. We'll find out soon when the judge issues his ruling. First of all, the judge seemed to have no interest in Donald Trump's proposed timeline, which would just take forever. Donald Trump didn't even want to address the immunity argument until after the election. Judge Chutkan seemed to have no interest in that. Second of all, it seems like the judge is going to allow prosecutors, probably sometime soon, probably before the election, to submit evidence, grand jury transcripts, FBI, what we call 302s, which are written statements, things that wouldn't already be in the public sector. So that can help prosecutors to put some damaging information about Donald Trump out there before the election, which of course Trump's team doesn't like. But big picture, there's a huge burden for Jack Smith here in terms of immunity. This is going to get appealed, possibly back up to the Supreme Court. There's a chance this case either gets reduced further or knocked out altogether.
And Paula, Judge Chutkan didn't seem to buy the defense's argument that Trump's interactions with Vice President Pence, when he was pressuring Pence to do something unconstitutional with electoral votes, the Trump team is saying that should be immune from prosecution within the confines of immunity and presidential actions. If she rules against the Trump team on that, Trump no doubt will appeal this all the way back up to the U.S. Supreme Court, right?
Yeah, I can confirm for sources familiar with their strategy, they will absolutely appeal to the Supreme Court. I'll go a little further than Ellie. This case is going to go back to the Supreme Court. Whether they want to hear it, that's up to them.
but parties associated with this case believe there was an implicit invitation by the Supreme Court to apply their opinion to this case and then come back if there are any additional questions. And whoever loses on this question about Mike Pence is want to go back before the Supreme Court to get some clarity, because Mike Pence's testimony, that of Bill Barr, that's the ball game for the Trump team. They believe if they can get that tossed under the Supreme Court's opinion that they believe says anything they can prove an official act can't be used as evidence, they believe the case is dead. So they're going to fight. They're going to fight to the death on
So,
that.
Ellie, I understand to a degree Judge Chutkan's impatience with the argument that the Trump team's making, because they're the ones that have been delaying, and now for a case to happen, and they say, oh, you can't do it in the closing days of the election. I mean, it's the closing days of the election because they've been delaying. But having a trial so close to an election, that's unusual, right?
Right. It was interesting to hear today, to hear Judge Chutkan say to Donald Trump's team, we don't think about the election date at all. Now, that's the textbook thing to say, but let's be real. There's some hypocrisy here, because in the early days of this case, Judge Chutkan was very much aligned with Jack Smith in a mad rush to get this case tried before the election. The original trial date was 7 months after the indictment. That's outrageous. You can't try a case with 13 million documents 7 months after the indictment. No case would normally get to trial that fast. So Judge Chutkan and Jack Smith were clearly very much thinking about the trial date, the election date, when they wanted to get the trial in before the election. But now that the tables have turned because of the Supreme Court's decision, all of a sudden from Judge Chutkan, it's, oh, we don't think about such things. I take that with some grain of salt.
And Paula, Judge Chutkan adjourned today's hearing without setting a trial date, saying that the issue of presidential immunity is going to continue to be litigated, as you just noted, and that setting a state date would be an exercise in futility. Do you agree?
Yeah, and she would know, because back several months ago, she was insistent that this case was going to go to trial in March, and we all saw that that is not how things played out. And of course, we have the election. If Trump is reelected, he's going to have his attorney general dismiss this case, dismiss Mar-a-Lago. Why would you put a trial date on the calendar right now when there's so much work to be done? And at this point, it is still not a guarantee that this case will survive and make it to trial.
Welcome to The Lead. I'm Jake Tapper. We start this hour with breaking news in the election subversion case against Donald Trump. The judge in the case just set a schedule that could result in the release of some of the evidence against Mr. Trump before the November election. Let's get right to CNN's Caitlin Polantz and CNN's senior legal analyst Ellie Honig. Caitlin, what could this never-before-seen evidence consist of?
Well, this was what the prosecutors were quite explicit in describing in court today. They want to file their what's called the opening brief on presidential immunity, and they've got lots of exhibits. They said this, Tom Windham said, we want to set forth the facts of this case, both in and outside of the indictment of Donald Trump. Things like grand jury transcripts, 302s, which are FBI memos of interviews they conduct with people, interview transcripts, additional interview transcripts, documentary evidence, all of that they want to be able to attach to their court filing and show the judge, this is the evidence we have to try and prove that Donald Trump was acting outside of the presidency after the 2020 election. Now, we haven't seen this evidence before because the Justice Department collected it in the grand jury and with subpoena power that even the House wasn't able to have in their investigation. And so what they will do, the date that the judge has set now, September 26th, that's when they'll be able to submit this all to court, and then the judge can determine how much of it is public. So before we talked about the possibility of a trial for Trump, that's not happening anytime soon, no trial date. We talked about a possibility of a mini trial. That's not on the table for now. Instead, all of that stuff that you would see at trial, and even the transcripts of people who may have testified before a grand jury and then be called back to trial, that's what we are very likely to be seeing by the end of this month.
But Ellie, I'm sure if I were Donald Trump or one of his attorneys, I'd be thinking, we need to do everything we can to stop this evidence from being released. And let's be honest, they have friends at the U.S. Supreme Court who might be inclined to listen to that argument for any number of reasons, including the election. Are we going to see this evidence?
I think we are going to see this evidence. Now, this is exactly the scenario that Donald Trump's lawyers were arguing against and trying to avoid this morning. They said, let's not do the immunity issue at all until after the election because, and the lawyer for Trump said it, we don't want this stuff coming out. We have a sensitive presidential election coming very soon. Judge Chutkan clearly does not care. Now, to your question, Jay, can Donald Trump say, well, I want to appeal this scheduling order to the D.C. Court of Appeals? maybe to the U.S. Supreme Court. He will have no luck doing that. This is a scheduling order. This is uniquely in the discretion and the province of a district judge, a trial court judge. There is no way in my mind that a court of appeals or the Supreme Court gets involved at the micromanagement level of a scheduling order.
And step back, this is largely going to be about Mike Pence, what Mike Pence said to the grand jury, perhaps what his advisors said to the grand jury, people who did not initially want to testify willingly and were forced into testifying. We could see the exact words of what they were asked by prosecutors and how they responded. Maybe not live, but at least on paper, potentially a very powerful transcript.
Yeah, I imagine the judge would review first, though, to make sure there's nothing classified, nothing sensitive.
I'll get some more on this breaking story. Our legal and law enforcement experts are with us. And Laura Coates, let me start with you. So we soon could see never before seen evidence that the prosecutors are going to release about Trump in this election subversion case. What sort of materials do you think we're talking about?
Well, we're going to have information about the allegations to support the charges. Remember, they have not actually changed. It's still the same four, but the underlying notions of how they're going to support it outside of what they believe to be possibly immunized testimony, statements that were made to encourage lawless activity, conversations that were outside of the realm of what are core constitutional arguments and duties as well. And we're not going to hear it all. There might be some that are still going to be sealed, but we're going to have information to support what the underlying issue is. And really, if you're the prosecution, you're looking at the defense saying, be careful what you wish for, you just might get it. If you want us to do a full evidentiary or on the papers discussion of what is official and what was not, here you go.
You know, it's interesting also, Andrew McCabe, that prosecutors have until September 26th to submit the evidence for Judge Chutkan to review. What kind of factors do you think she will have in reviewing whether to make this specific evidence, all of it or some of it, public?
Well, that decision in essentially letting the prosecutors go first was a core one to the fight that we saw play out in court today. Trump's team quite reasonably wants to slow this down, wants to put discussions and motions and possible avenues of appeal in front of that part of the case where we'll be deciding, sorting through the evidence and deciding what charges stay and what charges don't. The decision by the judge today was one sending a clear signal that no, she's going to go right to the evidence. And that will likely compress those issues in a way that they all get appealed at once, which again is consistent with what the prosecutors are seeking.
And she's making it clear that the upcoming election is not going to have an impact on her decision.
That's absolutely right. And I think that's consistent with what you're hearing from the prosecution as well. They are not worried about the election. They are worried about getting as much of this case done as they possibly can in the next few months. And of course, former President Trump is looking at it very differently. He wants to keep as much of this case out of the public consciousness before the election. And so we'll see them fight over those grounds.
It'll be a big fight. And Bill Brennan is with us, Donald Trump's attorneys. They're clearly likely to try to prevent this evidence from being made public, especially before the election, right?
They will, Wolf. And they'll have the blanket of the United States Supreme Court decision on immunity, which basically holds that anything done in a presidential capacity is immune. Anything that's done while president it's like a rebuttable presumption that it's immune. And if it's a private act, clearly private act, maybe not immune. But I'm sure that they're going to push as much as they can into the top pile, which is fully immune. And if they're successful, then it'll be dismissed again. If not, it'll go to trial.
If this never before seen evidence is made public, potentially it could have a negative effect on Trump going into the election.
Right. I mean, it's a little bit counterintuitive when the court says the election's really not an issue in this case, and of course it is. It's the calendar pages make it an issue. But then to release this material during the election season seems to bring the election into it. But we'll see.
We do know that the former Vice President Mike Pence, Laura, and some of other White House aides spoke to the grand jury in this specific case. Potentially what they said could be explosive.
And remember the role that they are putting Pence in now in this new indictment versus the previous one. It's more about him being the president of the Senate, less about being the running mate and second in command to President Trump. The reason they're doing so is because they're trying to compartmentalize the conduct of a president and the conduct of a candidate who's trying to continue to campaign. Having him as the president of the Senate is far removed from the actual vice presidency of the United States. Another point, though, it is, think about this. You're going to have the defense saying that, look, Jack Smith has tried to weaponize the government. They're trying to interfere with the election by even prosecuting Donald Trump. By highlighting it at all, you're trying to hurt. On the other hand, they want the judge to say, focus on the election, focus on the politics, because that's the only way that justice can be served. These two things do not, have the same mechanism for the judge, and the judge rejected it and saying, I'm not concerned with that calendar. It's been 11 months since we've had any hearing in this case. In that amount of time, a lot has changed, but one thing is not. She's still a trial judge over a current indictment.